we are going to walk you through how the prosecution, led by my Harvard Law colleague, Alvin Bragg, how they put together a masterful prosecution of Donald Trump and got a conviction on all 34 counts in literally less than 12 hours of deliberations. Bobby, Grace, and Mansfield Collins are with me in this hour. We were just on air 2 days ago talking about the trial, talking about the missteps of the defense team, what was strong by the prosecution team, what was strong even by the defense team. We had no idea that 2 days later we'd be back here talking about this conviction again across the board on all 34 counts. This news is reverberating throughout the nation and the world as it really ushers in a new era of presidential politics. Donald Trump, no matter what he says, no matter how he tries to spin it, no matter how many attacks he lobs at the judicial system, at the judge, at the jury, at the prosecutor, the reality is that he will carry the stain of the verdict during his third run for the White House and really throughout his life. And to be clear, he is not able to pardon himself like he might be able to do if this were a federal conviction. He's not able to, insert himself in any way in this judicial process. This was a prosecution by a state district attorney, a district attorney that was elected by the residents, the citizens, the voters of Manhattan. They elected Alvin Bragg. Alvin Bragg was charged with following facts that lead to criminal conduct and then prosecuting those individuals that engage in criminal conduct, despite who they are, despite what title they may have, despite how rich they may be, or how popular or famous they may be. And I just want to, again, shout out Alvin Bragg for having the courage to stand up to arguably one of the biggest bullies. That's what he is. Donald Trump is a bully. He attacks everyone. Doesn't matter who you are. And he stood up to Donald Trump. He took the heat. He took the vitriol. All the folks that doubted him, all the folks that attacked him, all the folks that said this case was weak, that said there wasn't enough evidence, that this wasn't the right case to move forward first, at the federal case in terms of the insurrection, Donald Trump's efforts to overturn the election, that should have been the first case. All of those folks now should be, and I hope they are, saluting Alvin Bragg and giving him his props, giving him his kudos, recognizing, as we would say, what he's done. I mean, he literally single-handedly, I'll say, and when I say that, I don't mean without a team, because obviously he had a brilliant team of lawyers inside that courtroom for the trial, but he single-handedly stood up to a former president who believes that he is above the law, who's being aided in some ways by his belief that he's above the law by our Supreme Court that heard arguments almost 2 months ago about his claim that he should be immune from all criminal prosecution. There's no reason that we don't have a decision back from the Supreme Court on that case. There's no reason that the case in Florida for the mishandling of classified documents is being handled by a judge that Trump appointed, Eileen Cannon. There's no reason that that case is not set for trial. So, we cannot expect the federal judiciary, the federal court system, to save us from Donald Trump. In this case, it is the state prosecutors, whether it's Letitia James, who, let's not forget that $450 million civil judgment she got against Donald Trump. Let's not forget the case, the RICO case that's pending in Georgia by District Attorney Fani Willis. And now today, Alvin Bragg making history as he is the first citywide, district-wide, county-wide elected district attorney that has obtained a guilty verdict against a former president who happens to be running for president again. In this hour, we're going to walk you through that trial, the highs, the lows, the evidence that was presented, and try to help you understand how the jury arrived at this verdict literally in 12 hours. Now, Trump showed very little emotion inside the courtroom as he learned his fate. But when he emerged outside the courtroom, his jaw was tense. He spoke to the television cameras that had assembled. He declared that the verdict was a disgrace. No news there. But with a somber expression, he's proclaimed that the real verdict is going to be on November 5th by the people. And of course, he's referring to Election Day. The judge overseeing the case has set a sentencing date for July 11th, and this is just days before the Republican National Convention convenes, and where we expect that he will become the party's nominee, barring some unusual circumstances. Now, what happens at that sentencing hearing is yet to be determined. The judge could impose a prison term of up to 4 years. Trump obviously could also just face probation. He's vowed to appeal. He's shown no contrition, no remorse. He will remain free. A lot of folks have been talking about him going to Rikers. Not true. He's going to remain free until the sentencing, and he will continue, as we expect, campaigning. But we cannot in any way overstate the significance of the prosecutors in this case and the verdict that they obtained and the brilliance and the trial strategy that was used by Alvin, Bragg, and team. And here to help us break it all down is Bobby Grace and Mansfield Collins. Welcome back, guys. I did not expect us to be together again so soon, to put the band back together again so soon. I thought, this jury would take at least a couple of days into next week before they came back. Let me start with you, Bobby, veteran prosecutor. You've been inside hundreds and hundreds of trials. Were you at all surprised by this verdict?
No, Areva. I think you are in Mansfield talked about this, that the prosecution really laid out a perfect case with respect to the facts related to business record fraud, right? That was very airtight. The only question was going to be, any curveballs that the defense was going to be able to throw in that really related to politics more than the actual nuts and bolts of the trial. I will point out one thing. One reason why I love conspiracy counts is because you get an opportunity to put in the record in front of the jury, even before they hear any evidence, all of the facts or all of the things that you said that these folks did in order to plan and effectuate whatever crime that they're going to do. Here, the news media has been showing the actual verdict forms and jury instructions that were given to the jury in this particular case. And it was clear that Alvin Bragg and his team, put all their chips in the poker table, talking about the underlying crime here, which was election fraud. And that's kind of the best way to describe it. Was the public defrauded by the fact that they had hushed up this payment to Stormy Daniels and Karen McDougal and the what's the guy? He was a doorman, and that basically defrauded the public in terms of what they knew going into the election. Would they have voted differently? We don't know, but we know from this trial that he did it, and there's no question about that. And everybody, including in Trump world, they're going to have to deal with the fact that this president is convicted of 34 counts related to this hush money payment, which comes back full circle. And I'm sure that the Trump organization thought that they would not have to deal with this going into November. Now they do.
Yeah, in Mansfield, something happened today that gave all of us lawyers a clue that there was going to be a guilty verdict. And that's when the jury, the four-person, told the judge that they had reached a verdict, but they needed 30 minutes. Tell us why that was significant and why that was a big clue for all of us to know that it was going to be a conviction on these charges.
Areva, it shows the absolute professionalism of these jurors, because they wanted to make sure that the public understood that even though they arrived at their decision fairly quickly, that they still debated, deliberated, and were determined to present the front that they looked at all of the evidence, and they needed to go through 34 counts, and they wanted to have it documented that they went through each count very carefully before they reported out to the court the final official verdict. And so I think that there were two lawyers on the jury. I think that was probably an extra step that the two lawyers or maybe a layperson recommended, listen, I don't want anybody to think we just rushed to judgment. Let's fill out this form. Let's take our time. And that's what they did. And yes, when they did that, if it was going to be a not guilty, there is no form. You just simply come back, tell the judge that you have a verdict. There's a not guilty means you don't have to answer anything on that form. That's the clue that we knew that this was coming back as guilty.
Yeah, I was explaining that to someone. They're saying, well, what does that matter? I said, if it's not guilty, it ain't nothing to do. It's just a simple not guilty. But because it's guilty and because there are 34 counts, you've got to go through and answer all the questions on these jury forms and make sure you've done it meticulously. And that's what happened in this case. Bobby, 12 hours. Now, there were folks who I think were prepared to, be on jury watch for at least verdict watch, I should call it, for the next 3 to 5 days. Again, you've tried a lot of cases. I'm sure you've tried cases like this, business falsification, business record, white collar financial crime cases. Is this 12 hours? Is this a short amount of time? Is this the usual? Or was this pretty lengthy given the simplicity of this case?
Well, it's right in the middle. I think that the fact that they took a couple days indicates that they were thoughtful. I think it was a simple case in the business records aspect of it. It's only weighty because it's the former president of the United States, and it has a lot of significance this year because it's an election year. But in terms of what was proven in court, I think Alvin Bragg said it best, that, this is something that the Manhattan DA office has been doing for 90 years, that they kind of specialize in this type of white collar crime. And so the only really difference here was that it was Donald Trump. But the jury meticulously went through all 34 counts. And frankly, again, Areva, the facts of this, the nuts and bolts of this were pretty easy because it was clear that he had falsified business records. The only question was going to be, were they going to hold him accountable to it on the level of a felony, which the jury felt it was.
I'm glad you brought that up, that Alvin Bragg's office, talked about how routine this is. This is the financial capital of the world, New York City. So it would stand to reason that the DA's office in Manhattan would have as its bread and butter these kinds of white collar financial crime cases, because you've got all of this financial activity. You've got thousands and thousands, tens of thousands of people who are working in, investment banks and insurance companies and other financial institutions. And this kind of fraud is not uncommon, happens a lot. And their office has developed an expertise in prosecuting these cases, which, Mansfield, when Alvin Bragg brought this case, there was a lot of criticism of him. Folks said this shouldn't be the first case, that this really isn't a felony, that, if it wasn't Donald Trump, there's questions about whether it would even be charged. He took a lot of flack, as DAs often do when they, bring cases involving high profile people. But what did you see in this case early on that gave you confidence that this is a case that could have been and now has proven to be a winnable case for the prosecution?
There was information in the public domain regarding the evidence that was going to be used in the trial against Donald Trump. But we didn't see the evidence. The only persons that are the prosecutors and the defense. And so that's what Alvin Bragg told his team. Follow the evidence and the law will be there at the end for you. And that's what his team did. They followed the evidence. This is a white collar crime with an extra twist of federal election, hushing up the white collar crime to allow him to avoid disclosing something to the public that affected a federal election. But it's basically a white collar crime. There are thousands of white collar crimes in the United States committed on a weekly or monthly basis. Most of them take place in federal court. But yes, we should celebrate Alvin Bragg in this moment, because Alvin Bragg is an African-American DA. Bobby Grace is an African-American DA. Judge Chutkin is an African-American female judge. Fani Willis is an African-American DA. Letitia James is an African-American Attorney General for New York. we should celebrate all of these individuals, not because of their color, but because of their qualifications and because of their commitment to justice and a true sense of what it means to be a patriot under these difficult times that this country is going through. So I just want to deviate for just a moment and say thank you to all of them in one level or another. Thank you to all of them, and we should be proud of them. We celebrate rappers a lot, but we should be proud to celebrate these Black female and male lawyers.
Yeah, no doubt about it, Mansfield. This is Black excellence at its finest. And you're right. We revere our actors, our sports figures, our hip hop artists, our R&B artists, and we should revere these people who are doing the business of holding our democracy together. I mean, because the system worked today. It worked today. This was a routine business, falsification of records case involving a district attorney's office that has, made this the staple of its office. There was a mountain of evidence that established that crimes were committed, a jury of his peers, of Donald Trump peers, and the appropriate response from that jury, conviction on all 34 counts. One of the things happened, Bobby, after the convictions were read, after the courtroom was cleared out, Trump's attorney literally shouting at the judge this motion for an acquittal on the basis of Michael Cohen's testimony, saying the whole verdict should be thrown out because it was based on Michael Cohen's testimony. We know defense lawyers have to make every post-trial motion possible. They've already vowed to file an appeal. That's their constitutional right, and they should do so. But what do you make of that motion, that motion for acquittal, and the stated reason that the jury somehow relied on Michael Cohen's testimony, and that made the whole verdict flawed?
Well, the how they did it, Areva, wasn't even in the correct form. Usually what happens is somebody is found guilty, and then you have an opportunity and not only to appeal, but more importantly, and you know this from our discussions with the Margaret Lee Thomas case, that you have an opportunity to come forward and ask for a new trial or ask for the case to be thrown out. And usually that's done, again, through papers, not with some shouted out motion that the prosecutors didn't even get an opportunity to view. Again, this was show for the one person who's most important to the defense in this case was Donald Trump, and I'm sure he felt better with them having shouted out that in court. But clearly this wasn't the proper venue for it, and the fact that they even did it shows that they were grasping at straws with respect to anything that the judge was going to do at that point.
Mansfield, we just shouted out these district attorneys, attorney generals, and these officers of the court as they should get their props. But we got to give some props to the jurors in the city of Manhattan. The Manhattan jurors have been handling their business, from the $5 million first judgment, civil judgment that E. Jean Carroll got against Donald Trump, to the $84 million judgment that second civil jury gave to E. Jean Carroll for defamation, now to this jury of his peers in Manhattan, again, a city that Donald Trump used to own, that was synonymous with his name. The jurors have said, we are not intimidated by you. We're not afraid of you. We're not afraid of your followers. We're not afraid of the vitriol. You cannot bully us. We are going to go where the evidence takes us. We're going to listen to the admonition from the judge, and we're going to render a decision consistent with the facts, the evidence, and the law. And I just think it takes so much. We know jury service. People hate jury service. They do everything in their power to get out of it. But what we saw today just goes to amplify how important jury service is and why it's important. When you get those notices, don't throw them away. Serve on jury. You are needed. When we come forward, got to talk about the evidence that was presented, what's going to happen at the sentencing hearing on July 11th, and what are the prospects for an appeal. So, Bobby, a couple of days before the Republicans are going to meet to nominate their candidate, and at this time, there's no reason to believe that they're going to nominate anyone other than Donald Trump. But he's going to be back in front of this judge, a judge that he has attacked, with, facing sentencing. and walk us through what happens at a sentencing hearing and how Donald Trump's repeated attacks on the judicial system, the judge, the jury, and the witnesses, how that's going to fare or play into what's going to happen at that sentencing hearing.
So what will happen, Areva, is that both sides will file motions to the court, basically asking the court to do what they feel is the best outcome with respect to the case, given the fact that Donald Trump was convicted of 34 felonies. So we know that the felonies that he was convicted of were E felonies in New York. That's the lowest felony that you can be convicted of, which basically means they are white-collar crimes, nonviolent crimes. Typically, offenders don't get sentenced to prison time for these types of offenses. But you mentioned that this particular defendant has said a lot of things attacking the judicial process, attacking the prosecutor, attacking the judge. He violated 10 times a gag order. That's all going to be factored in terms of whether or not a judge would sentence him to prison on this particular case. I would be very surprised, and I'd like to get Mansfield's take on this too. Very, very surprised if Alvin Bragg does not ask for prison time. Additionally, I would be surprised if the judge doesn't sentence him to prison, and here's why. Even though it's a E felony, we know the underlying conduct related to the E felony, basically election interference or a fraud on the public, which in turn may have resulted in his election. What could you imagine a more worse crime committed by a person than election interference? Two, this particular defendant has been threatening the judicial process, threatening jurors, and putting everybody that's involved in the case, putting their lives literally at risk because of his megaphone. I think everybody in Alvin Bragg's office, I think the people of New York would be sorely disappointed if Alvin Bragg doesn't ask for prison time. And I think a good portion of the country will also be very disappointed if Donald Trump, given what he was convicted of, would not serve a day in custody for what he did. I think it would show a lot of disappointment for a lot of different people within the criminal, who look at the criminal justice system, observers of the criminal justice system, and it would speak to two-tier justice. Why is Donald Trump going free and other people being held accountable? I would point to other individuals, politicians who have been convicted of white-collar crime. Some have gone to prison, some haven't. But I can't imagine any more egregious violation of an E felony than what Donald Trump was convicted of in this case.
And to your point, Mansfield, a part of sentencing is looking at whether this person is likely to recommit the crime. And by every indication, Donald Trump would be a repeat offender. There's nothing that would suggest that he would not go and do this all over again. One, because he hasn't accepted any responsibility for doing it. He's never, ever acknowledged his role in any of this. Everything is somebody else's fault. It's the judge's fault. It's the system's fault. It's the jury's fault. Never, ever is it his fault. And I'm also thinking, Mansfield, about how defendants typically, and this is what you've done throughout your career as a defense attorney, how you present a case to the judge as to why your client should not be sentenced to jail. And typically you talk about the good works they've done, the good character, how this is somehow an aberration and a deviation from their normal course of conduct. What is Donald Trump's defense team going to say to the judge in favor of why he should not get jail time, other than I'm busy running for president?
I guess the only thing they're going to say is Michael Cohen was a liar, because you're right, Areva, and I agree wholeheartedly with Bobby. In sentencing, you're supposed to offer some form of mitigation if you don't want to actually commit to going to jail or prison. I can't think of anything that that Donald Trump has done since the start of this trial and before this trial that could be developed into some sort of mitigation. He has promised to terminate the Constitution. He has promised, he has called this proceeding a kangaroo court decision. You know, the judicial system sort of will reward individuals who, like you said, Areva, show some degree of remorse, show some degree of accepting responsibility. Donald Trump not only he never accepts responsibility. Remember, this is someone that said he has never actually apologized or said he was sorry for doing anything in his entire life. So under these circumstances, I think the system is looking at Mr. Trump as someone that if he shows no responsibility, and by the way, there is that contempt proceeding that's going to be part of the sentencing. And remember that contempt is a quasi-criminal proceeding in and of itself, where the judge found beyond a reasonable doubt that he had basically threatened the judge, threatened witnesses. And so the sentencing is going to include the contempt charges as well as the sentencing on this conviction today. I would be surprised if he did not receive a sentence. It may be when we talk about going to prison, we talk about low term, midterm, high term. It may be a low term prison sentence, but I would be surprised if he was able to avoid any prison sentencing at all. I would be deeply surprised and saddened.
So Mansfield, define for us what a low term prison sentence would be? How many months would that be typically?
So if the range of sentencing in New York for this felony is 4 years, low term would probably be something like 16 months. Midterm would be the difference between the 16 months and the 4 years. And I think that, you're supposed to earn some consideration for a departure from the high term. I just don't see Donald Trump ever receiving an award for a departure from the high term, because his conduct has never changed. He has said that he's not going to follow this judgment. He's not going to follow the conviction. He's telling his people that it was unfair, that it was a kangaroo court. I mean, you can't at the same time give someone special treatment by giving them a lower sentence from their prison term and then allow the person to say that it was a sham trial. I've never seen that work that way. Maybe Bobby has, but I never have.
That's what's so interesting. So Mansfield, you've been at this a long time, and you just said you can't even create in your mind a mitigation brief. You can't come up with a story of mitigation that would be credible. And we know that to be the case because during some of these contempt hearings on violations of the gag order, the judge got very frustrated at one point with the defense team and says, you're not making legal arguments. You're just saying that he's running for president. That's not an argument. So his own defense team could not come up with justification for why he continued to violate the gag order. So this defense team is going to have to probably die. This is what I predict. He's going to tell his team, because of his arrogance and because of his hubris, don't even try to make any arguments. Don't even go in and even suggest that I'm, remorseful or that I've accepted responsibility. Continue to make the same arguments that this was a sham trial, a sham verdict, that it was based on Michael Cohen, who's an admitted liar. And basically, we want no parts of anything happening in this courtroom. We'll see you, at the appeals court. We'll see you at the U.S. Supreme Court. That's my prediction, is that he continues to play this game that I'm not going to even belittle myself and try to even, participate in this process because it's so beneath me, which is what he's done, which is why he's now a twice impeached and convicted felon. He can add that to his resume. When we come forward, I do want to talk about, though, you guys feel pretty confident that this judge may give him some jail time. The question becomes, when does he serve it? Because if there's a July 11th hearing, the jail time is, if you all are right, given at that time, he literally could be in jail when the election is taking place in November. What does that mean for our Constitution and for our democracy? Okay, Bobby, July 11th, big day. Maybe gets pushed back a couple of weeks or so, but let's assume that on July 11th, the sentencing hearing moves forward and the judge does what you and Mansfield predict, which is sentence Donald Trump to some jail time because of his conduct, because of his refusal to accept responsibility, because of his continued attacks on the judicial system and on the process. Typically, when you get sentenced, would you get months before you have to turn yourself in? Or how would that typically work, recognizing that it may not work the same for Donald Trump, who will be in an election that will be coming up fairly soon after July 11th?
Well, typically, if it was a violent crime, he'd be in custody right now. So there's that. White collar crime, defendants generally are not remanded at the time of the verdict. They get an opportunity to ask for a new trial, and they get an opportunity to argue sentencing. So at the sentencing, if there is an arguable claim on appeal, there may be times on this state side that a judge would allow someone to remain out on bail pending appeal. We know from our talks with about Mark Ridley Thomas that it's more typical on the federal side. Generally, in the state side, when somebody gets sentenced, particularly on violent crimes, but sometimes on white collar crime, particularly cases where a lot of money has been stolen or defrauded or part of a fraud case, they get sent. When they get sentenced, they're going into custody.
Wow.
So that's going to be a big factor here, and bears watching. The whole world will be watching, on that sentencing date, whether the judge remands Donald Trump into custody if he is in fact sent to prison.
Let me ask you this, Mansfield. So let's assume again, walking through this July 11th hearing, the prosecution makes this argument for why there should be jail time. They outline all of the attacks that Donald Trump has made on the system, on the case, on the verdict, on just about everybody involved. The defense gets up and makes whatever argument it can make. Their argument pretty much so far has been he's running for president, and all of this is designed to somehow thwart his efforts of becoming the president. And now they're going to add to that argument that the verdict is flawed because it's based on the very flawed and tortured, as they would call it, testimony of Michael Cohen. Of course, they're going to be arguing for no jail time, for no penalty at all, maybe a fine or maybe some kind of probation. But assuming that doesn't work with this judge, and there is a determination by the judge that there should be jail time and he should be remanded on that day, what happens if he then still wins the presidency? Because the fact that he gets arrested and they have to make arrangements, we know Eric Adams has already said, Mayor of New York, that they're already making arrangements to be able to accept him into their prison system the way they would any other prisoner, keeping in mind that Secret Service is involved. But if he is sitting behind bars in July, in August, and there's an election in November, and say by some weird fluke he wins, would he have the ability to then free himself, to overturn the conviction, to pardon himself? Like, what powers would he have as president of the United States?
Well, this is where the country finds itself right now in a legal state of trauma that's been created by Trump in this matter. Generally speaking, people of high morals, of high principles, would not have put the country through this process. They would not have put their party through this process. They would not have put their followers through this process. Because when it backfires, look at what we end up with. A convicted felon that now you are supporting for president. I think that we learned in law school, and it's always stuck with me, for every wrong, there's supposed to be a remedy, right? For every wrong, there's supposed to be a remedy. This is a question of first impression. There have been other congressional politicians, maybe even senators, that have been convicted of a felony, and they've tried to hold on to their positions in Congress, even though they were convicted as felons. But this is the first time a former president running for a new term has ever been convicted. So this is a new area for the courts and lawyers to deal with. And I almost sometimes want to suggest that that this issue should be reviewed as an injunction, maybe in federal court or state court, because no way, no how did the founders of the Constitution and of this country ever believe that this scenario could happen.
What do you mean, Mansfield, when you say an injunction?
That has indicated. Say that again.
What do you mean when you say an injunction, handled like an injunction?
There is no provision in the Constitution that says a convicted felon can't run for office, can't run for president. But that's because they never thought that could ever happen. An injunction would be a document filed in court, a mini lawsuit filed in court saying these are the reasons why, with all this record in front of us, that this man is not qualified and should be declared ineligible to further pursue the presidency of the United States. Only in a world gone mad would we not think of doing that right now.
Right. I got you. Okay. Understood. Understood. We need Lawrence Tribe or someone to file that motion on behalf of the citizens, the United States, citizens of the United States.
That's
we
right.
need Emeritus Professor Lawrence Tribe to do that. We're running out of time. Just real quickly, let me ask you this, Bobby. Again, that question: would Donald Trump be able to pardon himself if he is elected president and free himself from jail if he's sitting in a jail come November?
He won't be able to pardon himself because it's a state crime. I think what legal observers are asking, will the Supreme Court interject itself here once the appeal is filed and it goes through the New York levels and eventually gets to the Supreme Court? We already know that Justice Alito has said that presidents should be immune from anything. And so there's a real fear here that if it does get to the Supreme Court and he's in custody, the Supreme Court would step in and free him, basically on the argument that he's the elected president of the United States and he really can't do that from behind bars.
Yeah, and there's a possibility that Joe Biden may want to pardon him as well. We can think of lots of reasons why he would want to do that in terms of the stability of our democracy. We are out of time. Thank you so much, Bobby, Grace, and Mansfield Collins. Always a lot smarter when we spend an hour with you. So folks are going to feel like they got a law degree after watching and listening to this show and the shows we've done on these big pressing legal cases. Again, thanks so much. Next voice that you hear.